Good morning. I'm Ross Sandler, Professor of Law and Director of the Center for New York City Law, and I'm delighted to welcome you to the City Law Breakfast, and I congratulate you on braving the snowstorm and the cold and getting here. So thank you for being here. Let me introduce our Dean and President, Anthony Crowell.
Thanks so much, Ross, and good morning, everyone. And thank you for being here on this morning of the aftermath of the snowstorm of 2017. This is our first City Law Breakfast of 2017, and I am so happy that what we anticipated to be a packed house turned out indeed to be a packed house. So I love that the spirit of New Yorkers cannot be undermined by just a little weather. So it's really great. And we're really happy to have Oath Chief Judge Fidel Del Valle with us for this first breakfast of the year. Administrative tribunals are critically important for the city and for our overall justice system, the administrative justice system. And I worked very closely with Oath and many of the city tribunals when I was in city government and helped work on the overall consolidation of a lot of the tribunals under Oath's jurisdiction. And I'm really proud of the work that has been done to effectuate a far more efficient and responsive system, and one that the overwhelming number of New Yorkers who interact with the justice system are people who interact with administrative tribunals. So it's critically important that city government ensure that process and effectiveness and efficiency and fairness is always in place. I want to give a shout out to David Golden, the Administrative Justice Coordinator for the city, who did a lot of that work. Where is David? I just saw. David is, when I talk about a lot of the work that was done during the Bloomberg administration, David was at the front of that, leading and really thinking very strategically about how to make a better system. And so thank you, David. It's nice to have you here as we hear from the Chief Judge and Commissioner today. So with that, I will turn the mic back over to Ross, who will give more formal introductory remarks. Ross?
Again, I welcome everybody, and before I begin, I would like to thank some of the people who are really responsible for these breakfasts. First, our founding sponsors, Greenberg Traurig, the law firm of Greenberg Traurig. There's a table there. Thank you for being here. Con Edison, I know there are people from Con Edison that are here, and Verizon as well. And I also like to thank those with the gold star on your label. That means that you voluntarily contributed, and we thank you very much for supporting these breakfasts. I'd also like to thank the staff of the center, Brian Kasuba, the Associate Director, Lillian Valle Santiago, our Assistant, and Jesse Deno, and Jonathan Sizemore, and we have students from our classes here who have been helpful this morning. I want to thank you for getting up early and for and making sure that this was all set up during the snowstorm yesterday. I'd like to speak a little bit about Oath and what it means to the city. I know Fidel's going to give us a lot more, but I would like to give you just one fact. I went over to their new offices, which are very nice, very judicial, and very courtroom-like. And the first thing you see when you walk in is a set of a little display that says about interpretation. And I brought just a copy of it. They're prepared to do simultaneous interpretation in 22 languages, some of which I had not realized were being used in New York. Just think of that. That kind of preparation and demand on an administrative agency in New York is enormous. We've also here at the law school had a long-time relationship with Oath, going back to the days of Charles McFall, John Spooner, Ray Kramer. In the mid-90s, they came to me as we were starting the center, and they said, we have all of our decisions electronically filed, but we have no way to get them out to the public. We use them, but the public doesn't. So could you put them on your website? Well, we didn't know how to do that, but we bought a program that was really designed for law firms, and we uploaded those decisions, and that was the beginning of City Admin. And today, there are 29 city agencies, 130,000 administrative decisions on City Admin. On your tables is a paper that is the it's the home site or the page where you can search. If you haven't used City Admin, please look at it. It is really a wonderful resource, and it's the only place you'll find the oath decisions and the conflicts of interest decisions. We maintain that work for the city, and so we go back into the late 1990s on oath. And I'd like to thank Oath for giving us the opportunity to start that process. I feel very comfortable introducing Fidel del Valle. He and I worked together in the 1980s at the Taxi and Limousine Commission when he had started as counsel to the commission. He has held many important positions within city government, working at the police department, the probation department, and Taxi and Limousine Commission, where he was chair from 1991 to 1995. He brings tremendous experience and judgment, which is really wonderful in government, and I count him as a friend. He grew up on the on the Upper West Side of Manhattan. His parents, father from Cuba, mother from Puerto Rico. He went to Cardinal Hayes High School and Fordham University and NYU Law School, and then into government and into private practice back and forth. But he really has brought the kind of, I hate to use it, seichel. You know what seichel means? Yeah. To city government, which is so much needed, and particularly in an agency that is evolving, taking on new responsibility, bringing in other agencies, ALJs, trying to coordinate, bringing new ideas to something that is so important to the city government, so important to the city employees, many of whom unfortunately have to deal with oath. So the idea of fairness and justice, bringing that to this important agency is really critical. So we are delighted to welcome to this podium Fidel del Valle.
Thank you, Ross. What I'd like to do this morning is basically two things. One, tell you what is oath, because a lot of people don't know what oath is. I get questioned all the time, what is oath? And the other thing, more germane to a lot of people in this room I know, is where oath came from, how did it get to where it is now, and where we expect oath to be in a couple of years from now. Before I get into that, I want to put this all in context. And the context, I think, was brought up very vividly recently by a Justice Department report called the Ferguson Report in Ferguson, Missouri. And a letter that was sent by the Justice Department to all the chief judges in the United States back in March of 2016. And what I'm talking about is something that is creeping in like a bacterium, I would say, in the justice system for low-level offenses in the United States. And I'm talking about policing for profit. There's an excellent article in the Harvard Law Review entitled Policing for Profit. It came out in 2015 that covers a lot of the spectrum throughout the country with examples. So it tells you that Ferguson was not a unique situation. And that situation being that whether it's in administrative law level like it is in New York City or in the criminal court or district court level throughout the country, where the system, the procedures and the practices and the policies have been perverted in such a way as to make it almost impossible for respondents to really defend themselves, and the goal of the exercise basically is to make money. That's the ugly side of running government like a business, because the function of a business is to make money, whereas the function of a government is to govern. But that's not what I'm really going to talk about, and just put that in the back of your head in the context of what I'm about to talk about. What is OATH? OATH is the Office of Administrative Trials and Hearings. A really, really, really neat acronym, I thought, when I first heard it back in 1979. I don't know who came up with it, but I really like it. Ed Koch was mayor of the city of New York in 1979, and he had this revolutionary idea, and I mean revolutionary in the sense that it goes back to our founding fathers, that if someone is brought up on charges of some kind by a city agency, a government agency, they should expect to have a fair and impartial hearing on those charges or allegations by someone who is impartial and unbiased, and certainly not someone who is within the agency that brought the charges against them. And in that regard, Ed Koch signed an executive order creating oath on July 25, 1979. And I'm just going to quote the beginning of his memo on that. And this is from Ed Koch. City administrative trials have too often been characterized by procedural shortcomings and inconsistent, judicially reversible results. It has therefore become necessary to reform the due process trial system by establishing a new Office of Administrative Trials and Hearings. Ed Koch created oath with Richard Fela as its first chief administrative law judge on that date. Way back then in 1979, I was working in the New York City Probation Department as a brand new, squeaky clean lawyer, just graduated from law school a couple of years before that, in my first grown-up job. And my boss comes up to me and says, by the way, my job was to, among other things, prosecute administratively disciplinary cases in the probation department, disciplinary cases against employees, not probationers. My boss comes up to me and says, this guy wants to follow the civil service law Article 75 process on a disciplinary case instead of going through the contract grievance procedure that ultimately leads in arbitration. Employees at the time had the option of either going the contract procedure or the civil service law procedure. And in fact, more than 90% followed the contract procedure at the time. So I say, fine, wonderful, great. This is, just out of law school. I get to try a case. This is fantastic. How do I do it? And the response was, I don't know. You're the lawyer. Figure it out. You hear that a lot, too, by the way. So I do, I'm pretty good at research. I decided to research it and found absolutely nothing. So I swallow my pride, pick up the phone, and dial the number down there in the bottom of the directory for oath. A guy picks up the phone at the other end, and I tell him, in my trying not to be too squeaky voice, I'm a brand new baby lawyer who just got this assignment, and I don't know what to do. What do I do? And the guy at the other end of the phone very nicely says, no problem. I'm going to fax over my calendar, and you can come and sit with me and watch how it's done, and when you're ready, you can try your case. That was Richard Fela. He was the first chief administrative law judge of the city of New York. Oath at the time consisted of exactly 3 people: the chief ALJ, his secretary, and a part-time stenographer. And they would go riding circuit, like in the Old West, from agency to agency. We find them an empty office or a conference room, and he would sit there and hold court. Both has grown a little bit since then. As many of you who here have learned in law school, administrative law is very loose on the requirements of due process and rules of evidence. As you know, it could be very informal. It could be hearsay, or whatever is thrown into the pot can go in. Richard Fela had a very different vision. Ed Koch had a very, very different vision. As far as they were concerned, it was, no, we're not going that way. This was before oath had its own set of rules. He said, we're going to follow the CPLR as closely as possible on procedure, and we're going to follow the rules of evidence as close as we can. And that was an education, Because if I wanted to introduce, say, a document that listed somebody's latenesses, I first had to identify it for the record. I then had to qualify it, lay a foundation for its being admitted into evidence, whether it's a business record or it's a certified document, some exception to the hearsay rule, and then make a motion to have it admitted into evidence. I'm going to be drinking a lot of water because I'm on antihistamines. The whole proceedings were extremely formal, as though you were in federal court, basically. And I've practiced a lot in federal court since then, not before that. For 35 years, roughly 30 years, more like 30 years, since that time, Oath remained with the initial portfolio that was given to it by Ed Koch, which was doing complicated, for the most part, complicated trials relating to disciplinary cases, Human Rights Commission cases, contract dispute cases, eventually police forfeiture retention cases. These are cases that are conducted in a courtroom formally with an ALJ at the bench and both parties represented before them in a courtroom. In fact, at some point, I moved from the probation department to the police department, where I was the attorney in charge of the then new nuisance abatement law and civil rights cases where police brutality was alleged. Well, that's my introduction into federal court. But eventually, I reached the TLC, where I was Deputy General Counsel and counsel and eventually chair. And I, at one point or another, over the period of years I was there, which was about 10 years, referred about 350 medallion cases from medallion owners for revocation of their licenses or forcing them to divest of their licenses. And those cases went to Oath because Oath did license revocation hearings. That is not automatic hearings where you hit a magic number and you're automatically revoked, but where you do something so egregious that it demands that your license be immediately revoked. Well, it won't be immediate because you have a full trial at Oath. The interesting thing is there were about 350 of these cases, some of them involving tens of millions of dollars worth of medallions. The cases were appealed ultimately to the appellate division, which is where most cases go after they leave Oath, but all the way up to the Court of Appeals in Albany, and they were all uniformly sustained, all the way up to the Court of Appeals, because of the meticulous manner in which Oath conducts its hearings, the way Oath ALJs write their decisions. Something to be very proud of. Then flash forward a few more years. I was then in private practice, and Mayor Bloomberg decides to dust off Ed Koch's old memo of 1979, where he envisioned that all cases in New York City, all administrative trial cases, would be an Oath, and asks David Golden to head up a committee to study bringing those tribunals into Oath's orbit. To make a long story short, it was decided, for various reasons, and I think pretty good ones, to take the Taxi Tribunal that was in the Taxi and Limousine Commission, the Health Tribunal, the ECB Tribunal, which was in the Department of Environmental Protection, and the Consumer Affairs Tribunal, and pull them into Oath. The first three, and this was done under the prior administration, were surgically excised lock, stock, and barrel, and I mean lock, stock, and barrel. I'm including the stationery, the bodies, the chairs, everybody. And pulled out of the agency they were in and put like little planetoids under oath. They were like separate little planets. Flash forward now again to October 2014. I had decided to basically retire. I had wound down my practice for the most part. I was sitting at home at my computer staring at the Medicare website trying to figure out what is A and B and how in the world do I commit to one or the other, and looking at the small print saying if you commit to one or the other, you're married for life. I mean, at least I could get a divorce, but you're really stuck with this thing. And I'm literally sitting at the computer looking at this, and my cell phone rings, and it's Mayor de Blasio and Tony Shores on the phone. And basically they offer me the position of chief ALJ. And immediately it struck me, well, this is coming full circle for me. And this sounds like a really neat deal, and it beats the heck of trying to figure out Medicare. And I accepted the offer. Mayor de Blasio, and this is critical, gave me that night on the phone 2 instructions. And those were the only 2 instructions he has ever given me. He said, number 1, make sure anybody who gets a ticket in the city of New York gets a fair, impartial, and unbiased hearing. And number 2, make sure that everybody in the city of New York who gets a hearing believes he got a fair, impartial, unbiased hearing. And I said to myself, well, that's a piece of cake. I know oath. I've had experience with oath, even in private practice a few times. I know you get a fair, impartial, unbiased hearing. So I said, yes, I took the job. I got to oath, and just to put it in perspective, oath in 2007 consisted of 35 people. Today, oath is over 600 people, mostly as a result of these tribunals being sucked into orbit under oath, originally under orbit. What I found was that the oath tribunal, as I knew it, with the ALJs, the 10 ALJs, functioned exactly as I expected that they functioned for the last 35 years. When I spoke to folks who were respondents at the 3 tribunals that were already under orbit at oath, nobody, not a single human being told me that they ever thought they got a fair and impartial hearing. Absolutely nobody. I've spoken to city council members, I've spoken to community group people, I have spoken to people randomly at hearings. Nobody believed they got a fair hearing. They thought the system was rigged, that the object of the exercise was to generate money for the city of New York. Remember what the context I mentioned before when I started speaking. When I spoke to the people working there, there was a total disconnect as to their view of what was going on and the perception of what the public saw. They thought they were doing God's work. They saw their mission as, some of them told me, to educate people on how they should conform to what agencies want them to do. That whatever it is that the agency wants people to do is in the greater good, and like that. What I also found was a system where the procedures varied wildly depending on where you got a summons from. It could be returnable in 14 days, it could be returnable in 30 days, it could be returnable in 45 days. We had 4 computer systems at oath that didn't talk to each other, being fed by 10 computer systems in the city that didn't talk to us and didn't want to talk to each other. You got a sanitation summons. Nowhere in the sanitation summons did it say sanitation department. Nowhere. Unless you happen to know that the little code, number code at the bottom of the summons was the sanitation code. People thought they were getting summonses from the Environmental Control Board because it's the top of the summons said Environmental Control Board. And then the procedures were so arcane that 10 lawyers couldn't figure out what you had to do. Somebody would walk in to one of our centers and want to take care of a summons, and we couldn't take care of it, and they thought we issued them the summons. It was 2 weeks after they got the summons, and we would be telling them, we can't help you because we don't know that the summons ever existed. Because the system is so arcane that we would get the paper like 3 days before the hearing, which is 30 days, which puts the respondent in a bind, and besides which makes us look incredibly stupid. You had crept into the system over time, and I can speculate, and I'd rather not, as to why, but you would have agencies that would issue their summonses all returnable at 8:30 in the morning. So at our facility in Brooklyn, for example, you could have 800 summonses come in on one day, all returnable at 8:30 in the morning, and the agency sent only 4 people to prosecute the summonses. Now, even if I populated the building with 40 hearing officers, you couldn't process them all at the same time. One inspector, for example, whose name comes to mind, but I will not mention in order to protect the guilty, would issue 27 summonses returnable on the same day at 8:30 in the morning. There's no way on God's green earth that you can do 27 hearings at the same time. So you have people sitting there at 2:30 in the afternoon holding a summons that says 8:30 in the morning. And when I talk to the folks like that, they'll say, well, it's obvious that the reason this happens is because you just want me to pay the summons. And if I have the audacity to try to contest the summons, I have to lose 2 days' pay. So you just want me to pay the summons and walk away. And it's hard to tell somebody that's not the plan. So I had a meeting with Anthony Shorris, the first deputy mayor, and he came up with a plan and a direction on where we're going to go, which is, on its surface, sounds very simple. One summons, citywide. All summonses from all agencies to look essentially the same. Some agency summonses are 8 pages long, believe it or not. This is a simple, stupid summons. We're not talking about a federal indictment here. And in those, of those 8 pages, maybe there's information that has anything to do with your case on 2 of those pages. Some summonses are like 8.5 by 11 monotype, which you would have to do a research paper just to figure out what the heck it meant if you weren't used to it. And procedures varied widely all over the place. Part 2 was one uniform procedure system throughout the city. Each agency has its own rules, but oath rules of practice will be uniform regardless of who writes a summons. And number 3, which has turned out to be the most onerous challenge, is a uniform technology to deal with the summonses. The goal being on the outside is that anybody who writes a summons in the city of New York will be doing it on a tablet. The tablet will have uniform instructions with pull down depending on what agency you are, and the moment that the summons is done, somebody is served with the summons, and our computer system would immediately know what the summons is, what it looks like, and somebody could walk in the door the next morning and deal with it if they want to. People would be able to go to any of our tribunals. We are in 5 boroughs, any of our forums, and be able to deal with any summons they got from any agency 5 days a week. That is going to be complicated because it's easy for us to write that rule. It's not so easy for agencies to change 50 years of practice and budget issues. Right now, we have implemented uniform procedural rules. They went into effect in August of 2016, citywide. We are in the process of, we have created with the various city agencies a uniform summons. It is being introduced by agency, piece by piece. The new summons has all kinds of unique little features in it, like on top of the summons it says the name of the agency and its logo, and where you have to go to get it adjudicated, and what exactly you are charged with. We've instituted, and this actually had its genesis before I got here, a program where people can contest summonses online. They can contest them by phone, and the way it works by phone is you say you want a hearing by phone, and you will be giving a time and a date, which is usually a half-hour range, where you will be phoned, and the hearing officer will be there, and if necessary, somebody from the agency who prosecutes it, and you can do it over the phone, and you can upload whatever documents you want online. As Ross Sandler told you before, we have the ability to translate any document from any language that you want to submit. If it's a document, give it to us a few days in advance, and we'll provide you with a certified copy for the hearing. If you go into the hearing, we have phones that can have translators online to do the translating, and I've watched this and I've heard it, and it's amazing how good they really good are. Having done lots of EBTs in my life, and having to stop some of them because I knew the translator wasn't translating properly. It's kind of handy when you know the other language that's being translated and the witness says something and that's not what's translated. It's really, really bad when the witness stops his own translator and says, "That's not what I said." And I've had that happen a couple of times. I'm not going to bore you with the technology issues, but they're being worked through, and the city's spending millions of dollars in upgrading a lot of the technology problems. The first deputy mayor told me that if an agency tells me that they're having problems budgeting for bringing their technology up to speed, to let him know, and he'll find the money for it, and he has done that. Some agencies have told me that they're a little slow in adjusting their programming because they're having trouble finding COBOL programmers. I'm not kidding. For those of you who are too young, back in 1969, when I was in college, I used to do programming in COBOL. That was the business programming language of the time. It is extinct. And the problem they're having finding programmers is that they didn't get a forwarding address to their cemeteries. They did find a few. Some agencies didn't have that problem because they didn't have any computers. Everything was on paper. Now, we process right now approximately almost 3,000 cases that go to the trials division a year, of which about 750 go to full trial at Oath, at the Oath Trials Division. On the hearing side, we take in, last year we took in, I believe, something like 840,000 summonses, of which a little over 300,000 went to a full hearing. One of the parts of the reorganization, and it has to do with the procedural stuff, is that we have eliminated the planetoids. We have eliminated the taxi tribunal, we have eliminated the health tribunal, we have eliminated the environmental control board tribunal. There is now one oath hearings division. When late last year, actually, as of I believe October, we absorbed consumer affairs cases. We did not take in the consumer affairs tribunal. It was disbanded. The venue of those cases was moved by mayoral order to the oath hearings division. We were not going to start all over again with another tribunal, bringing it into to speed. That is the work in progress that we're involved with right now, and where our goal is eventually to have anybody who gets a summons in the city of New York at any time be able to go to any of our tribunal locations and have it adjudicated. The goal is to have the technology able to do that and people able to understand how to deal with the summons, and to make it so simple, stupid, that somebody can take care of a summons without having to go, unless it's some bizarre situation, get a lawyer or anybody else and not have trouble figuring out how to do it. Some agencies were told that we were going to stop having people sitting around all day because they got a summons that said 8:30 in the morning. I informed several agencies that were doing that we were going to call their summonses within 30 minutes of the time that they put on the summons. And if they're ready to go, fine. If the respondent is there, fine. If the respondent is there and they're not there, we're going to go forward anyway. And if the summons stands by itself, okay. If it's faulty and it's brought up at that time, it'll be dismissed. And if the respondent is able to refute anything on the summons, it will probably be dismissed. There was, as you can imagine, a lot of gnashing of teeth, rendering of garments, and folks heading towards City Hall with pitchforks and torches, and essentially the mayor's office and first deputy mayor said, too bad. The Taxi and Limousine Commission, where I worked for 10 years, I know for 50 years was able to stagger summonses. It's not genius. All you have to do is make sure your inspectors have a watch. And by the way, and I'm not kidding, I did volunteer out of my budget to buy Timexes for any agency that needed watches for their inspectors. It is not a simple process, though. If somebody wants a hearing on demand, very often many of these hearings require, excuse me, the inspector to be there for the hearing. And we have to develop a matrix for that process. We also have to know that certain agencies are unaccustomed to being on call citywide at the same time for hearing purposes. What some agencies are doing is they are developing a cadre of prosecutors that can go instead of inspectors, and inspectors can be in the field. And this is not uniform right now. It's coming in by agency as each agency can get online. For example, the Port Authority Police. We get a lot of summonses from the Port Authority Police, believe it or not, because they write summonses to vehicles for hire at the airports and at bus terminals. Port Authority police officers testify by teleconferencing now. We have the equipment. They have the equipment at JFK. A case comes in, a cab driver, for example, who wants to contest a summons, and he wants the officer who issued the summons to be cross-examined, which is his right. He's there on the monitor, and you can do it. Our goal is to do that for everybody at some point. Some agencies have major technological hurdles to deal with doing that, but at the end of the exercise, we're going to be doing that. In fact, and this wasn't at the hearings tribunal, this was at the trials tribunal, we had people testifying against drivers whose licenses were up for revocation from Germany by teleconferencing and from Australia by teleconferencing. And you got to imagine how ticked off somebody has to be in Australia to get up at like 3 o'clock in the morning to testify against a cab driver in New York City by teleconferencing. But it happens, and we do it. One point of clarification. I said we eliminated the little planetoid tribunals. What we did is we took oath and divided oath into two divisions, the trials division and the hearings division. The trials division is like Coke Classic, is Oath Classic. It is populated by 10 ALJs, administrative law judges, who handle cases in much the same way that they've been handled for the last 35 years. The Oath Trials Division is the senior division, was the original. The Oath Hearings Division is where we amalgamated all of the cases that involve summonses. The main difference between whether something goes to trials or hearings is that a summons is something you typically take care of anywhere in 15 to 40 minutes. And it's based on a summons an inspector gave you on the street. The trials division is complicated cases like loft board cases where you may have 35 witnesses, boxes of documentary evidence that has to be reviewed, a trial that goes on for 2 or 3 weeks, and a huge report that goes at the end. The city charter is very, very specific in only one place where it names who is an ALJ. An ALJ, according to the city charter, is someone appointed by the chief administrative law judge to a 5-year term. That came into place in 1988 when Oath became a chartered agency, almost 10 years after Ed Koch created it by executive order. That is not, it's not accidental that that's 1 year longer than the mayor's term to further ensure impartiality. In the hearings division, the hearing officers are attorneys. They are on attorney lines. ALJs, by the way, at the trials division, have a unique civil service line which says administrative law judge. They're the only line that you get, a payroll line that says administrative law judge. Hearings division are per diem, for the most part, per diem agency attorneys assigned as and hired as with the house title of hearing officer, or in some cases, older cases, hearing examiner. And that's their title. Just so everybody's clear on who is who and what's what. I know that back in 1980, starting at TLC, hearing officers started calling themselves ALJs. For clarification purposes, I went back to what the original system is. Just like in federal court, you have district court judges, and you have magistrates. District court judges deal at a certain level with certain level of cases, and magistrates at a separate level. And that's one of the ways I rationalize it. What's the plan for tomorrow is Oath will follow religiously the concept that was originally in Ed Koch and Richard Thaler's vision, that when you appear, whether it's a trials division or the hearings division, the person hearing the case stands absolutely neutral with the agency on one side and the respondent on the other side, and the agency has to establish by itself that it gave proper notice in each element of the alleged offense. And the respondent has an equal obligation on his own to try to refute or rebut it in one fashion or another. There was a practice in the past, and I'm going back to the general context of what I was talking about before, where when the tribunals were proprietary and an inspector or whatever failed to cite properly the notice provisions or left something out in the elements of the offense, believe it or not, and I'm not going to mention the agency, again, to protect the guilty, the hearing officer was expected to fill in the blanks for the agency and turn to the respondent and explain to the respondent how they should comply with the agency's requirements. In fact, a managing attorney at one of our locations once asked me with a straight face, "What are you trying to do, turn us into a court?" Yeah. And you didn't think it was? In any case, that's where Oath is, and that's where Oath is going. I think we should keep in mind that since the New Deal back in the first half of the last century, there has been more and more administrative law in this country, where more and more of government is run and operated, and rules are mandated by administrative law, by agencies, whether it's an agency that's headed by a commission like the TLC or an agency that's headed by a single commissioner like Consumer Affairs, and that the vast majority of contacts that the population, that the citizens or non-citizens have with government in this country is with an administrative agency or an administrative tribunal. And when they walk away from that contact, that's their image of their government. And if they think that their government is ripping them off, that does not bode well. That is the formula that is spelled out in the Ferguson report of what happened over there, because at a certain point there's an explosion. There's built-up resentment. And it undermines the very integrity of government. The founding fathers back in 1783 had the right idea when they thought of creating an executive, a legislative, and an independent judiciary all on equal standing. Because if you lose that impartial arbiter, you lose a lot, and you definitely are sowing the seeds of discontent. That's basically all I have to say. I think Ross wants to have a Q&A, which I'll be very delighted to participate.
We have microphones over here and there, and we invite people to come and make comments, short comments on short questions, and because we will always end on time at 9:30. So let's start over here.
Good morning. Is this on? Yeah. Peter Mazur. I'm General Counsel to the Metropolitan Taxi Cab Board of Trade, and in my former life, had the privilege of serving as an hearing officer for the Taxi and Limousine Commission and as Chief Administrative Law Judge. I have a specific question for the Commissioner. We hear a lot now that there is talk about transferring some of the criminal court summonses that are now returnable to the various summons parts to oath. And the question I have, what procedures will oath put in place to assure that the due process requirements that defendants get to expect in criminal court, such as the right to confront witnesses, the right to cross-examine, and the right to be convicted on exclusively non-hearsay evidence, will also carry forward to the oath tribunal should they get jurisdiction over these summonses?
Well, we're going to get jurisdiction over these summonses come, I believe, July of this year. And we are working on the mechanics of integrating that into our system. There shouldn't be any real difference on the procedural and evidentiary aspects of those cases versus the cases we will be having at the Hearings Division. I envision that the Hearings Division due process and evidentiary practices will be more in conformance with what they are at the Trials Division right now. Right now, when something that's hearsay wants to be introduced, the administrative law allows hearsay to be introduced, but it has to be introduced with a foundation that goes to the nature of its worth. And as I speak to ALJs, they tell me they accept hearsay, but generally it's worth very little or next to nothing, depending on the way that it is submitted, what the foundation is, what is the basis for it. Hearsay that is a certified document from a government agency is not a problem. That's a clear exception to the hearsay rule. But if it's one of these he said, she said, that kind of thing, it becomes next to worthless. And that's what I expect will happen. The unique thing about these summonses, and we expect, and we're only guessing right now, that it'll be about 145,000 more summonses a year, is that for the first time we will be hearing summonses that allege personal misbehavior. This is what I mean. Summonses that now come to the Hearings Division are generally business-type summonses. Even when it's a summons against somebody's private property for not sweeping the sidewalk, it's related to that property and that business of owning that property. It's not alleging that John Doe was a dirty person and dirtied the sidewalk. We will be getting those summonses now. Summonses that allege personal misbehavior on somebody's part, whether it's littering or bicycle riding on a sidewalk or whatever. That puts a very different context in it. In part for that reason, and in part because of a lot of confusion on the part of people coming to the public at the Hearings Division as to what they can do, what they can't do, we just created an Office of the Ombudsman and Pro Se Clerk at oath. Pro se, as an attorney understands, is basically the function of the pro se clerk. Like in federal court, you show up in federal court on your own and you have no idea what you're doing. There will be people at each location whose job will be to take people by the hand and show them what the ropes are and what they can do, how they can do it, what their obligations are, and so forth. They are not allowed to give them legal advice. They are not allowed to represent them. That would be a no-no. That would destroy the impartiality of the agency. But because of that, they will be doing that. One of the things that came in unexpectedly was the requirement that they threw in there in the Criminal Justice Reform Act of community service. I lobbied for that to be handled by the probation department, and the commissioner of probation did as well. I worked at the probation department. I know most probation officers are social workers. You need an MSW to be a supervisor. But it was deemed to be too criminal sounding, so we're going to be doing that, and we're working with the Center for Innovation and Justice to come up with programs that are more functional and basically make the process a teaching experience, that it's more than just send somebody out and tell them to collect leaves on a street or sweeping or something like that, that they learn that basically their conduct was inappropriate. But that's coming in, I probably kick in really in July of this year, and we're working very closely with the police department to coordinate how they issue summonses and how we receive them and what the summonses look like and like that.
Susan Lindenauer, who you know as co-chair of the New York County Lawyers Association Task Force on Administrative Law. I really appreciated your excellent summary of the history of oath. What I'm curious about is the per diem hearing officers. Are they in any way selected, monitored, or scrutinized by the agencies issuing the summons, or is this all under oath?
It is all under oath. And in fact, early on, when I did my little survey and found out that folks didn't believe they got a fair hearing and whatnot, from some hearing officers, I heard that they received considerable pressure from agencies, particularly when they were part of those agencies, to rule in a particular way. They're represented by the United Federation of Teachers now, and that is a big issue for them. And I wasn't kidding when I said to them, and I still say it now, that if anybody from any agency tries to put pressure on any hearing officer of any kind to rule in any particular manner or other, and that person happens to be an attorney for that agency, I will personally make a complaint to the grievance committee of the appellate division against that individual. If that individual happens not to be an attorney, I will then push to have charges brought against that individual for tampering with the process. The hearing officers are selected by screening committees within oath of senior hearings people, experienced hearings people, who review their resumes and interview them. And it's a various stage process. So we're confident that our hearing officers are independent and know they're independent. And as I've told them at a CLE class a few months ago, I don't care whether they rule for or against an agency in a particular position, but if that agency has a problem with their ruling, then they can cry to their commissioner, and if their commissioner wants, they can cry to me, and that's as far as it's going to get. Of course, I will support them completely. Whether they're right or wrong, it's their call.
Thank you.
And there's an appellate process, by the way. Once there's a hearing at the hearings division, the agency or the respondent can appeal that decision. And it goes before a group of experienced hearing officers. Many of them are full-time former hearing officers who will review the case and modify it, remand it, or overturn it, or affirm it. And eventually, this is the only weakness in the system, eventually in many cases, the agency can ultimately appeal to itself. That happens very rarely. I have seen it happen, and I have seen it happen with bizarre results. And that is something that can only be fixed legislatively.
And then it goes to an Article 78, I would assume.
Yeah.
Yeah. Thank you.
This will be the last question or comment.
It's handy that you're the last guy standing.
Excuse me?
You're the last guy standing.
My name is Jim DeVore. In a past life, I was a lawyer for 237 of the Teamsters Union. I've been, as I said, in prior life. I do recall and remember that you were always known as one of the good guys in the days when you were general counsel at TLC and throughout your career, and I just want to express that approval. Now, you answered part of my question, or you anticipated most of my question, but the query I have is, under the applicable civil service law, in essence, the hearing officer makes a report and recommendation, which may or may not be followed by the agency. And again, one bizarre result that I had was a taxi driver who had the misfortune of having the complaining witness against him be the commissioner of TLC and a cab ride. And in a moment of remarkable, his license was then emergency suspended, and in a moment of remarkable independence, Ray Kramer gave him like a 30-day hit, and whereupon the commissioner refused to put the issue before the Taxi and Limousine Commission for 2 years. Required an Article 78, and we got him some money. What do you do, or what do you recommend to avoid that kind of abuse that is rarely but affirmatively seen?
I remember that case, and it was actually before I got to oath, but since I got to oath, there have been similar cases, and it actually wasn't as high as a trials division. It was a hearing division case where a rule said that in the event that the driver was found guilty of this offense, in addition to getting a fine, he could be suspended up to 30 days. And the hearing officer decided that based on the circumstances of this particular case and the mitigation, he will impose the fine but not the suspension. TLC appealed it to the chair of the TLC, who ruled, and we couldn't do anything about it, that in this instance where the rule says may, it shall mean must. And he was suspended for 30 days, and there was nothing we could do about it. My fantasy, all right, is that at some point, and this would require undoubtedly state, if not constitutional, amendment to the state constitution, that oath be considered part of the judiciary, where that can't happen. And there are other similar instances where I have seen summons dismissed because the wrong section of the ad code was cited, and it goes all the way up the line to agency, and agency says, oh, it doesn't make any real difference because they really knew what the violation was, so we're going to sustain the summons. It happens rarely, but it happens. I think it's inappropriate, and I think it undermines the credibility of the system, just like having a system that was rigged against respondents through procedures, or by having everybody come in at 8:30 in the morning, or having unbelievably arcane documents purporting to be summonses or notices of violation, which the term notice of violation I find totally obnoxious because it's saying you're in violation, come and try to get out of it. Now everything is called a summons. That is a weakness that's inherent in the way the system was created, and that's something that needs legislative fix.
Stay right here. For me anyway, one of the joys of doing this is to showcase people who are really long-time involvement with government and how well they do and how smart they are and how careful they are at doing their jobs. And I think this was really a wonderful opportunity to see one of the good guys of government. Thank you. As we like to do, we always like to give a product of the scholarship of this law school to our speaker, and this is a new book. It's actually going to be out next week, but this is an advanced copy of D.C. Confidential Inside the 5 Tricks of Washington by my colleague David Schoenbrod. You'll find this right up your alley. It's really about what's going on with Congress. So thank you again. Our next breakfast is in March. Thank you. It was terrific.